Welcome to the webinar on AI lawfulness, fairness and transparency, organised by the Information Commissioner's Office. My name is Ahmed Razik, and with me today are Abigail Haxton, Ruben Binns, Carl Wiper and Alistair Pearson. Today we will be covering lawfulness, fairness and transparency in an AI context. We will look at how to identify purposes and lawful basis when using AI, what you need to do about statistical accuracy, how to address risks of bias and discrimination, and how to ensure that processing is transparent. At the end of the presentation, we will hold a 10 to 15 minute question and answer session. Please use the chat function to ask questions to the panel. The ICO has recently published two pieces of guidance about AI. The first to be published was the guidance on explaining decisions made with AI in collaboration with the Alan Turing Institute. The second was the guidance on AI and data protection. We are running a series of webinars looking at common themes that run through these pieces of guidance. Our first webinar looked at AI accountability and governance and was held in September. You can listen back to this on YouTube. This webinar is on lawfulness, fairness and transparency. The next two webinars will be on security and data minimization and individual rights respectively. These will be held in November and December. I will now pass over to our first speaker, Ruben Binns.
Hello, thanks. So one of the first topics to cover here is how you decide on lawful bases for processing personal data when you're using AI. So if you're using AI with personal data, you'll need a lawful basis for processing. But it's important to note that personal data may be used in an AI context at several different stages in the life cycle. So it might actually be appropriate to have different lawful bases if the purposes for processing data are different along the life cycle. So at the beginning, you may be developing an AI system. You may be using various different kinds of data to experiment and work out whether an AI solution is going to be appropriate in your context and going to work. And so you might have one lawful basis for that purpose. But then later on, when you actually use your model, your AI model in a particular context, it might be appropriate to have a different lawful basis. So you need to think about how you'll separate out those different stages of the life cycle. Next slide. It's important also to note that it may be affected by whether you're using special category data and whether you're making solely automated decisions that have a legal or similarly significant effect. So when it comes to special category data, if you're not processing special category data, either as the thing that one of the things that you're using to make a prediction with your AI system or make an inference, or whether the thing that you're predicting or inferring is itself not special category data, then you just need to consider the appropriate lawful bases under Article 6 of the GDPR. However, if you're processing special category data, either as an input to your AI system or as the output of the system, then you'll need to consider both an Article 6 lawful basis and an appropriate Article 9 condition under the GDPR. Similarly, if you're processing data about criminal offences, you'll need an appropriate lawful basis under Article 6 and Article 10 of the GDPR. So those are things to bear in mind about lawful bases with respect to special category data and criminal offence data. If you're using AI to make solely automated decisions about people that will have legal or similarly significant effects, then you will need to identify an appropriate lawful basis under Article 22 of the GDPR, and these are more limited than the full range of Article 6 bases. As mentioned before, this is going to be different in the context of training your system, because you're very unlikely to be making solely automated decisions about people when you're just developing your system, but it may be different when it comes to deploying the system. So consent or legitimate interests are likely to be frequently used lawful bases. Consent may be appropriate if you have a direct relationship with the individuals whose data you want to process. Legitimate interest may be appropriate. It's more flexible, but it's not always appropriate given the context. So legitimate interest can include your own interest or those of third parties, as well as commercial and societal interest. There may be other contexts in which other lawful bases like contracts, legal obligation, public task, or vital interest may be appropriate. And I'll hand over to Alistair.
Thanks, Ruben. I'll talk a little bit about the difference between accuracy in a data protection context and statistical accuracy in an AI context. So accuracy in a data protection is one of the fundamental principles requiring you to ensure that personal data is accurate and, where necessary, kept up to date. Broadly, accuracy in AI, and more generally in statistical modeling, refers to how often an AI system guesses the correct answer, measured against correctly labeled test data. Your AI system does not need to be 100% statistically accurate to comply with the accuracy principle. In most cases, the outputs of an AI system are not intended to be treated as factual information about the individual. Instead, they are intended to represent a statistically informed guess as to something which may be true about the individual now or in the future. The statistical accuracy of your AI system's outputs will have implications for the fairness principle. In a data protection context, fairness generally means that you should handle personal data in ways that people would reasonably expect and not use it in ways that have unjustified adverse effects on them. Therefore, improving the statistical accuracy of your AI system's outputs is one of your considerations to ensure compliance with the fairness principle. The GDPR mentions statistical accuracy in the context of profiling and automated decision-making at Recital 71. This states organizations should be put in place appropriate mathematical and statistical procedures for the profiling of individuals as part of their technical measures. You should ensure that factors that may result in inaccuracies in personal data are corrected and the risk of errors is minimized. You should note that the GDPR's recitals are not legally binding, but do clarify the meaning and intentions of its articles. Overall, statistical accuracy is not a particularly useful measure and usually needs to be broken down into different measures. It is important to measure and prioritize the right ones. If you're in a compliance role, you should work with colleagues in technical roles to ensure that you have in place appropriate measures of statistical accuracy given your context and the purposes of processing. These measures should reflect the balance between two different kinds of errors. First, a false positive or type 1 error. These are cases that the AI system incorrectly labels as positive. For example, emails classified as spam when they are genuine, or a false negative or type 2 error. These are cases that the AI system incorrectly labels as negative when they are actually positive. For example, emails classified as genuine when they are actually spam. It is important to strike the right balance between these two types of errors. There are more useful measures which reflect these two types of errors, including precision, which is the percentage of cases identified as positive that are in fact positive, also called positive predictive value. For example, if 9 out of 10 emails that are classified as spam are actually spam, the precision of your AI system is 90%. Or recall or sensitivity. This is the percentage of all cases that are in fact positive that are identified as such. For example, if 10 out of 100 emails are actually spam, but the AI system only identifies 7 of them, then its recall is 70%. There are trade-offs between precision and recall, which can be assessed using statistical measures. If you place more importance on finding as many of the positive cases as possible, i.e. maximizing recall, this may come at the cost of some false positives, i.e. lowering precision. In addition, there may be important differences between the consequences of false positives and false negatives on individuals, which could affect the fairness of processing. It's important to note that statistical accuracy is not a static measure. While it is usually measured on static test data held back from the training data, in real-life situations, AI systems are applied to new and changing populations. Just because a system is statistically accurate about an existing population's data, for example, customers in the last year, it may not continue to perform well if there is a change in the characteristics of that population or any other population who the system is applied to in the future. Behaviors may change, either of their own accord or because they are adapting in response to the system, and the AI system may become less statistically accurate with time. This phenomenon is referred to in machine learning as concept or model drift, and various methods exist for detecting it. For example, you can measure the distance between classification errors over time. Increasingly frequent errors may suggest drift. You should regularly assess drift and retrain the model on new data where necessary. As part of your accountability responsibilities, you should decide and document appropriate thresholds for determining whether your model needs to be retrained based on the nature, scope, context, and purposes of the processing and the risks it poses. For example, if your model is scoring CVs as part of a recruitment exercise and the kinds of skills candidates need in a particular job are likely to change every 2 years, you should anticipate and assessing the need to retrain your fresh data at least every 2 years. In other application domains where the main features don't change so often, for example, recognizing handwritten digits, you can anticipate less drift. You will need to assess this based on your own circumstances. I'll now talk a little bit about addressing the risks of bias and discrimination and why bias and discrimination may arise in an AI system. The fact that AI systems learn from data does not guarantee that their outputs will not lead to discriminatory effects. The data used to train and test AI systems, as well as the way they are designed and used, might lead to AI systems which treat certain groups less favorably without objective justification. In our guidance on AI and data protection, we do not aim to provide guidance on legal compliance with the UK's anti-discrimination legal framework, most notably the Equalities Act 2010. This sits alongside data protection law and applies to a range of organisations. Demonstrating that an AI system is not unlawfully discriminatory under the UK Equality Act is a complex task, but is separate and additional to your obligations relating to discrimination under data protection law. Compliance with one will not guarantee compliance with the other. Data protection law addresses concerns about unjust discrimination in several ways. As mentioned earlier, processing must be fair, meaning handling data in ways people reasonably expect, and not use it in ways that have unjustified adverse effects on them. Data protection aims to protect individuals' rights and freedoms with regard to the processing of their personal data. This includes the right to privacy, but also the right to non-discrimination. The GDPR also states the use should use appropriate technical and organizational measures to prevent bias and discrimination where you are processing personal data for profiling and automated decision-making. An AI system may lead to discrimination for several reasons. One is imbalanced training data. If a machine learning algorithm is trained on a dataset where there are more men than women, say, then the model will pay more attention to the statistical relationships that makes predictions about men. This could mean it performs better on men than women. Another reason is that the training data may reflect past discrimination. If a model is trained on a dataset that has been historically discriminatory, for example, recruitment for traditionally male roles, then it is likely to reproduce the same pattern of discrimination. Other causes of potentially discriminatory AI systems include prejudices or bias in the ways variables are measured, labeled, or aggregated, biased cultural assumptions of developers, inappropriately defined objectives, for example, where the best candidate for a job embeds assumptions about gender, race, or other characteristics, or the way the model is deployed, for example, via a user interface which doesn't meet accessibility requirements. I'll now hand over back to Ruben, who will talk about some of the technical approaches to mitigate discrimination risk in machine learning models.
Thanks. It's important to note that, as Alistair said, this is not going to mean that by deploying any of these measures, you'll automatically comply with equalities law. It's also important to note that issues of discrimination are broader and can't realistically be fixed through modifying your AI system. That said, there are various approaches which have been proposed to mitigate AI-driven discrimination. And so some of these techniques may be useful to you in your context, but it's important to note that they're not a complete fix for the problem. So when you have cases of imbalanced training data, so for example, if you have a data set which contains a high proportion of men, it may be possible to balance out that data set by adding or removing data about the under or overrepresented members of the population. So for instance, you might add more data points on say loan applications from women if it's in a financial lending context, for instance. However, when the training data itself reflects past discrimination, then you have several other options. So you may be able to modify the data. So for instance, you might remove examples from the data which you suspect are likely to be the result of discrimination. You could change the labels of those examples. You may be able to change the learning process, so the way that the model learns from the data that you give it, so that it is constrained by various kind of statistical fairness measures. And finally, you may be able to modify the model after you've trained it, and that could either be by changing the rules around the model that you implement at a technical level, or it might be a case of how you present it to a human decision maker, so that they're able to understand the potential bias and discrimination from the model. So I'll hand over now to my colleague Carl Wiper.
Hello. So this is Carl Wiper. So what does the law say about transparency and AI? Well, data protection legislation refers to information that must be provided to individuals both before and after the processing takes place. It contains explicit requirements about automated decision making relating to situations where a decision affecting an individual is made by a system, such as one using AI, without any human involvement in the decision itself. And also the decision affects the individual's legal status or rights, or it has a similarly significant effect, that is, an equivalent impact on an individual's circumstances, behaviour or opportunities, for example, a decision about welfare or a loan. In those cases, Articles 13 and 14 of the GDPR give individuals the right to be informed of the existence of the automated decision making, meaningful information about the logic involved, and the significance and envisaged consequences for the individual. And Article 15 gives individuals the right of access to the same information on request. Article 22 has specific requirements around the provision of information about and an explanation of solely automated decisions with legal or similarly significant effects. This says that in these cases, data subjects have at least the right to obtain human intervention by the controller to express their point of view and to contest the decision. Recital 71 of the GDPR provides some interpretive guidance on rights related to this automated decision making. It says that specific information should be given to the data subjects and reiterates that after the decision, they have the right to human intervention, to express their point of view and to challenge the decision. It also says that they have the right to obtain an explanation of the decision. The reference to an explanation of an automated decision after it's been made in Recital 71 makes clear that such a right is implicit in Articles 15 and Article 22. So you need to be able to give an individual an explanation of a fully automated decision to enable their rights to obtain meaningful information and to express their point of view and contest the decision. Now, the provisions we've discussed so far relate to solely automated decisions. But what about situations where you're using AI to inform a decision that is made by a human? Here, you need to think about fairness and transparency, two fundamental bases of data protection. Given the complexity of AI systems and the fact they're opaque to most people but can significantly affect them, you should consider what information and explanation you should give to ensure that what you are doing with their data is transparent and fair. So what do we mean by giving an explanation of an AI system, whether before or after a decision is made? In our guidance on explaining decisions made with AI, we, together with the Alan Turing Institute, set out to provide some good practice guidance to help organisations with this. And we conducted research to try to determine what types of information people would reasonably expect in relation to decisions made using AI systems. And this research identified 6 key explanation types. These are, as you can see on the screen, firstly, a rationale explanation. That's how the algorithm made the decision. A responsibility explanation, that means who's responsible for the system and the decisions, and who can I contact to challenge or query it. A data explanation, because people often want to know what data about them was used to make a decision, because often they suspect it's inaccurate or incomplete. Then there's a fairness explanation. Am I being treated the same as other people who are like me, or is there any inbuilt bias in the system? And then what we call the safety and performance explanation, and that means how accurate is the system and how is that assured? And finally, an impact explanation. What's the impact of that decision on me, and what is the wider impact of the AI system on society more generally? Now, how and when these explanations should be provided to an individual and what should be provided will crucially depend on the context of the decision, and that means the domain you're operating in, the impacts, the type of data being used, the urgency and the intended audience. Okay. The next slide, please. Thank you. So the main aim of the explaining decisions made with AI guidance is to help organisations to explain to individuals how and why a particular decision's been made about them. And that means demonstrating how you and others involved in the development of your system acted responsibly when choosing the processes behind its design and deployment, and also making the reasoning behind the outcome of that decision clear. So we therefore divided each type of explanation into the subcategories of process and outcome, and how we define these is shown on the slides. A process-based explanation details why a particular system has been chosen. The explanation provided should include details of the measures taken in the system's development and deployment to ensure that the outcome is fair and safe. Whereas an outcome-based explanation will allow an individual to understand why a specific decision was made about them, including what data was used and how they can challenge it. If there is meaningful involvement, human involvement that is, in the decision-making process, you should also explain how and why the human judgment that is assisted by the AI output was reached. In addition, you may need to confirm that the outcome of an AI decision meets the criteria established in your design process to ensure the system is being used in a fair, safe and ethical way. In the guidance, we provide more details of how these two subcategories of explanation relate to the explanation types we detailed earlier. And Dr. Abigail Haxton will now talk in some more detail about how to provide an explanation.
Thank you, Carl. So when explaining a decision, it is important to consider when in the decision-making process the explanation will be of most use to the individual. Delivering an explanation is not just about telling people the result of an AI decision. It's also about telling people how decisions are made in advance. Before a decision is made, you can provide the process-based explanations referred to by Carl earlier. Where relevant, you can also provide outcome-based explanations relating to who is responsible for making the decision supported by the result of the AI system, for reviewing it and for implementing it, how you have assessed the potential impact of the model on the individual and the wider community, and what data was input into the AI system to train, test and validate it. You can then provide the full explanation after the decision has been made. There are some specific outcome-based explanations that you will not have been able to explain in advance. For example, rationale, fairness and safety and performance of the system, which are specific to a particular decision and are likely to be queried after the decision has been made. These explain the underlying logic of the system that led to the specific decision or output, whether the decision recipient was treated fairly compared with others who are similar, and whether the system functioned properly in that particular instance. In the explaining decisions made using AI guidance, we provide examples of these type of explanation that can be provided before and after an AI-assisted decision is made. Before you provide an explanation to an individual, you need to consider how to build and present the information in a clear and accessible manner. Remember, context is key. At all phases of your project, from the design and build phase through data collection and pre-processing to the decision output, you should keep in mind what information a decision subject would reasonably expect. You should consider both process-based and outcome-based explanations as part of this step, and also what explanation types you should prioritise. You should determine the most appropriate method of delivery based on the way you make AI-assisted decisions about people, and what their reasonable expectations might be. This might be verbally, face-to-face, in hard copy or electronic format. Think about the audience, such as reasonable adjustments you might need to make for people under the Equality Act 2010, or whether the decisions are about children. If you are using AI to make decisions about children, you should also look at our Children's Code, which sets out standards for age-appropriate design. If you deliver explanations in hard copy or electronic form, you should consider whether there are design choices that can help make what you are telling people clearer and easy to understand. For example, in addition to text, simple graphs and diagrams may help with certain explanations, such as rationale and safety and performance. Depending on the size and resources of your organisation, you may be able to draw on the expertise of UX and user interface designers. To ensure decision recipients are not overwhelmed with information provided to them, you could also consider layered explanations. And this means providing individuals with the most important information first, for example, the prioritised explanations, and making the additional explanations available on a second and possibly third layer. If you deliver your explanations on a website, you can use expanding sections, tabs, or link to web pages with the additional explanations. However you choose to deliver your explanations to individuals, it is important to think of it as a conversation. By providing an explanation, you're initiating a conversation and not ending it. Individuals should not only have easy access to additional explanatory information, but they should also be able to discuss the AI-assisted decision with a person. This ties in with the responsibility explanation and having a human reviewer. However, as well as being able to contest decisions, it is important to provide a way for people to talk about and clarify explanations with a competent human being. Finally, if you procure a system, you should ensure that you're able to provide this information to decision recipients. Explainability, in the terms we have set out here, should be factored into your procurement criteria. As a data controller, it is your responsibility to comply with the transparency principle. Now I'll pass back to Carl for information about our next steps.
Thank you, Abby. As part of the AI auditing framework, we want to produce further materials that will assist you with being compliant with data protection law and being able to demonstrate your compliance. We're currently developing a product aimed at individuals in compliance-focused roles, and we're looking for feedback and case studies to help shape our thinking. We'll be sending out a survey in the next few weeks to gain some initial feedback. If you've already given your consent to receiving materials from us, we'll contact you directly. If you didn't provide your consent previously, but you would like to receive materials from us now, including this survey, you can email events@ico.org.uk. As part of our work on explaining decisions made using AI, we plan to conduct an assessment of the usability and effectiveness of that guidance. And soon we'll be asking organisations to provide feedback if they've used the guidance in implementing and using an AI system. If you've agreed to receive further information from us, you should receive details about this shortly. And finally, the ICO is hiring. We're seeking experts in machine learning and other probabilistic computing techniques and the roles that these developments play in society. And we're also looking for people who have experience in data science. So for further information about that, you can visit the Technology Opportunities page on the ICO's website. Now let's have a look at the questions that you've asked us.
Thanks, Carl. Some good questions here. So most popular question comes from Alison. Hi, just wondering if you can give an example of when vital interests would be appropriate to use within the context of AI. Probably goes to Alistair here.
Sure. First of all, apologies for my sound cutting out during my speech. We'll provide the slides afterwards, and I can also provide a transcript of what I said. So in answer to the question about when would vital interests be an appropriate legal basis, in a very limited number of cases. So vital interest is usually an appropriate lawful basis where you're protecting the vital interests of the individuals. Traditionally it's used when someone's been in an accident, say, and that they can't give consent, and there's time pressure in terms of ability to process their data in order to help them. So applying this to an AI context, it's difficult to think of a contemporary example of a situation where AI could be used where vital interest would be the appropriate lawful basis, but maybe in an emergency medical diagnosis of patients who are unable to provide consent. So you might have an AI diagnostic system which could be used to process someone's personal data, something like that. But yeah, in short, a very limited number of cases where vital interest would be an appropriate lawful basis. But perhaps in the future there will be systems that are used in such scenarios.
Great, thank you, Alistair. We'll go to another question from Paul. As an AI supplier, how can I prove to my investors and clients that I'm compliant with lawfulness, fairness, and transparency principles? Is there any independent authority that can provide this confidence towards the systems I can generate? Who wants to take that on? It's a good question, it seems.
So our codes and certification teams are currently working alongside is it UCAS? Yeah, the UK accreditation scheme to produce codes and certifications that organisations can apply for, which could act potentially as an independent authority that can provide confidence towards the systems. However, it's probably important to note that the sort of how AI evolves and how it evolves very quickly, these codes and certifications probably have their limits, so they can definitely certify you at a point in time, which gives you that sort of reassurance that your system is compliant. However, you'll need to remain vigilant about how your system evolves and ensure that it's still processing data in a way that's fair, lawful, and transparent.
Just to add to that, thanks, Alistair. Certainly, I'd agree with those comments. Just to add to that, in terms of certification, it's important to remember that the ICO itself doesn't do the certification or develop the certification scheme. It's certification bodies would do that. So we have a role in that under the GDPR, but we're not directly doing that or certifying bodies ourselves as such. But I think that's certainly a positive development, and I think it's good that those provisions are in the GDPR, because I think as certification schemes and standards become more embedded in this area, then it will give some objective basis to attest these schemes. But I think really it's important to I think, or actually helpful to look at the guidance that we produce on this. We do try to provide sort of practical guidance on these issues, which not only sort of explains the law in general terms, but also, you know, does try to give some more practical help, and that's something which we are continuing to work on, as we mentioned in the presentation. So we will be producing more in the way of, you know, self-assessment tools and so on, to assist with this work. So I think, I mean, I appreciate it sounds rather like an advert for us, but you know, do check the guidance on our website in order to check your systems. And I think if you can say that you know, you're following that, then it certainly will help with compliance, because I think you have to remember as well that in data protection legislation there is the accountability principle. So you have to comply and be able to demonstrate that you comply with the legislation.
Okay, let's move over to the next question, which is about fairness. Which fairness metric should we use to evaluate fairness of our model? And what is a threshold for deeming that a model is fair? Does anyone take that one?
I can have a go.
Yeah.
So I think as we said, the choice of fairness metric, if any, is going to be completely context specific. And I don't think any of them would sort of comprehensively determine whether a model is fair or not, because it's a dynamic thing that will change over time. So I think it's not possible to answer that question directly. I would say that when it comes to the 80% disparate impacts doctrine from the US, you know, that's something that is the US based thing, and it's part of sort of US equalities law. So I'd look to UK equalities law, but as Alistair mentioned, that's not something that is covered by data protection specifically. So I would look to UK specific law and employment law and equalities law more generally.
Okay, thank you, Ruben. Question from Matt here. Should a data subject request information about an algorithm used in automated decision making? Would the IP owner of the algorithm have any grounds to refuse on the grounds of commercial interests?
I can speak to that if you like. We don't think that complying with data protection law and the requirements about automated decision making should create a problem or a conflict in terms of IP. I don't think that the information that you would need to give to be meaningful to an individual about a decision would be at the level of detail that would compromise IP rights. So at the moment we're very sceptical of the argument that would be a problem and that would prevent it. I think as well, because as we said in the presentation, what qualifies as a meaningful explanation is very much context dependent, and in our guidance we go into that in some detail. You know, what do we mean by context dependent? So it doesn't necessarily mean, you know, giving away the secret sauce of how the algorithm works, and we don't think that it has to involve that.
Thank you, Carl. Question on Article 22 from Anonymous. In order to avoid the application of Article 22, does human involvement need to take place after the automated decision has been made? So if human involvement only takes place in determining the data fed into the AI system, is this sufficient involvement to ensure Article 22 does not apply? A timely question. I
mean, I can speak to that unless one of my colleagues wants to pick it up. No, the simple answer is no, really. That if the human involvement is just in terms of putting in the input data, then no, that's not enough to take it out of the definition of a solely automated decision. Where in our guidance on Article 22, which is available on our website, we talk about this, and it has to be meaningful involvement by a human. So and also it's about the decision itself. The question is the system making the decision essentially, or is a human looking at the output from the AI system and then making the decision? And in the latter case, we would expect that the human would have discretion and knowledge and power to actually make the final decision, and isn't simply rubber stamping an AI system. So that's really about the human involvement. So just having humans inputting the data is not going to take it out of that definition. But I think I'd also say that I think it would be wrong to see the Article 22 provisions, the automated decision-making provisions, as a trap which you should try and avoid as far as possible. I think what they're saying is that this sort of processing, which is impactful and often opaque, can only take place in certain circumstances, although those circumstances are quite widely drawn there. And if you are in that situation, then you have to have certain safeguards which are about transparency and accountability and so on, as we've discussed in the presentation. So I think there is a way through that if you're using a solely automated system.
Great, thank you, Carl. Just to say that it's unlikely we're going to get through all the questions, but I'm trying to do it by popularity, which hopefully is an acceptable metric. A question again from Anonymous. When could consent be used in an AI model involving children's data, given the age-appropriate design code and the age of consent? Does anyone want to take that on, or should we move that off? We can answer that maybe afterwards, or make a note.
Yeah, I think it's probably best.
Okay.
We'll need to consult with the team working on the age-appropriate design code on this. Okay,
that's fine. How frequently do you think AI should be audited?
I think this very much depends, and it's context specific. It will depend on what the AI is being used for, what training data it's been trained on. Yeah, there's a myriad of factors that can determine how often you should audit an AI system.
Thank you. It's quite a good quick fire now. How can startups ensure compliance when there is not sufficient awareness or support when they are setting up? That's a good question. Is this another one to take back later?
I'm just thinking about the context of this. Could you just repeat the question, please? I was just looking for it in the chat. If you could just repeat the question again, please.
So it's from Melissa. How can startups ensure compliance when there is not sufficient awareness or support when they are setting up?
Okay. Yeah, sure. Well, clearly it is challenging, and I think we'd understand that. I mean, certainly when we were working on the guidance on the AI guidance, we talked to quite a range of organisations, you know, including small firms, small micro businesses really, who were saying that you know, the person who's dealing with these issues that you're talking about here is also dealing with, you know, several other major things, you know, with relations with clients or whatever. You know, we recognise that people are wearing several hats in these situations, certainly, and what we've tried to do through our guidance is produce some I hesitate to say simplified, but perhaps, you know, shorter, more impactful kind of guidance and checklists and so on, specifically for smaller businesses. So there is some of that on our website, and hopefully that would help as a sort of starter pack for organisations, certainly, and there will be more of that in future. And we also have an SME hub. You know, we have a contact point at the ICO that deals specifically with queries from and about smaller businesses. So we're trying to be helpful in that way. But I appreciate that in this context that we're talking about, we're really dealing here with organisations which might be quite small and perhaps not well resourced and just starting up, but they can be dealing with complex systems, the sort of AI systems that we've been talking about, and those systems often can be using special category data, for example. You know, they can be quite sensitive, quite impactful, etc., and also very complex. So I think you do quickly get into these areas that we've been talking about. We've tried to aim some of the guidance at technical people in the organisation, so it's not just for data protection officers, but you know, there's a level of technical detail which might be helpful to the technical people in those companies. So we're trying to do what we can on that, but certainly I don't, you know, underestimate. I'm not trying to dismiss the issue. We recognise it's a difficult world out there, particularly at the moment for the small business.
Thank you, Carl. Just flicking through. There is a question around, I'm trying to re-find it again. Where has it gone? Sorry, I'm trying to slightly. Okay, it's about agency of users, which I thought was interesting. How, as AI users, can we differentiate a prediction coming from a biased or fair, from a biased model or a fair and transparent model? Does anyone have thoughts on the user side?
That sounds like a question for Ruben, perhaps, or Alistair. I'm not sure. It depends on what they mean by user. So if they mean an end user, someone who is as a data subject is having a decision made about them, and they want to know if it's fair or not, I would expect that the guidance on explaining decisions with AI would be hopefully relevant to that question. In terms of, you know, if you're a user, you may also be able to make a subject access request, for instance. But hopefully that information would already have been provided to you, and if you still have suspicions, then you know you could pursue that further. If by user you mean a company or an organisation that has bought a system, an AI system, from another organisation, then I think sitting down with them or reviewing their product alongside the guidance that we've provided should hopefully give you the information you need to either find out directly or to ask them further questions that would enable you to see if they've taken on board the right considerations, and to see if that particular product will work in your context. So yeah, without further details, I'm afraid I can't give more information than that.
I think it's an interesting. Sorry, Abby. I was just going to say, I think it's an interesting question. It raises even more interesting questions. I think the difference between data protection law, which is very much about safeguards for individual rights and freedoms, and equalities law, which is more about discriminating outcomes for groups, and the intersection between there. So from an individual's perspective, how can they distinguish a prediction coming from a biased model or a fair and transparent model? I think that would be quite difficult, and it would have to be done from their perspective on an individual basis. So whether the result or decision that's been made about them is fair, and it'd be pretty hard to determine whether it has come from a biased or a fair model. But sorry, Abby, I interrupted.
No, it's fine. I was just going to say, just add that from the point that Ruben made about if you're talking about users as in data subjects, we would expect organisations to be able, as far as possible, to provide information about the data used to train a model. If there are some ways of providing reassurance that the data used to train the model is on a wide variety of individuals and circumstances, and maybe in the rationale explanation as well, there could be some information about how the system has been built to weight certain criteria in different ways in order to prevent bias within the system.
Thanks, Abby. Popular questions coming again from Anonymous. Would a law enforcement authority be exempt from providing any information about AI in their privacy notices? Oh.
Unfortunately, part of the scope of the guidance on AI and data protection, it mostly aimed at GDPR and Part 2 of the Data Protection Act. So we weren't able to talk about the Part 3 of the Data Protection Act, which is specifically designed for law enforcement agencies. So this isn't a question that we've thought about much. However, within the ICO, we're doing some work with law enforcement agencies and looking at Part 3 and the implications it will have for law enforcement using AI and data analytics and things like that. So look out for forthcoming guidance on that, I'd say.
Just to add, there are some comments on the law enforcement provisions in the explaining decisions made with AI guidance, and also, of course, there is guidance on the law enforcement provisions in the Data Protection Act on our website as well, which sort of goes into that issue.
Okay, thank you. Let's go to the bottom. A couple questions here. Let's go for one from Bill. With respect to the life cycle of an AI system, can the principles be retrospectively applied to data processing for development of the tool itself? So, for example, if the relevant processing and development of the AI tool took place prior to the enactment of GDPR, it's quite a complicated question, and complied with applicable ICO guidance at the time of that development.
So I think the question turns on whether there's still processing of personal data going on. So if you were to have built a model prior to GDPR, and that model itself doesn't contain any personal data, and you are still using that model, if that model doesn't contain any personal data, then the data used to train it is not being further processed necessarily. So in that case, that would be fine. However, if you are continuing to process the data that was collected prior to that, then I think the GDPR still would apply. But maybe maybe other people will be able to comment further on that.
I think that's okay. We've really overrun here, so apologies. Thank you all so much for joining. And I think, is that it, Suzanne? Can we wrap up comments? Oh.
Yes, that is. Hi, thank you very much to everyone for your input there and your questions. There's a few questions in the chat here that I've been responding to about the slides and the recording of the webinar. They will go onto the ICO website, and we'll send a follow-up email to everybody just with a link so that you can access that as well. Thank you very much.
Thank you.
Thank you, Vera.